Hi everyone, my name is Eugene. I'm going to step here to accommodate for the filming. Uh, I'm the Chief Counsel at the Interfaith Center of New York. And being a lawyer means that you spend a lot of time reading and thinking about and citing case law or precedents, decisions and opinions written by judges and other legal decision makers of the past who have confronted similar situations as a source of analogy, argumentation, and authority for how present-day legal disputes should be answered. And it might not surprise many of you to learn that many of the precedents that we're looking at today involving some of the worst past violation of human rights in the context of foreign policy and immigration come from the days of the Reagan administration. Back then, ICE, which was called INS, Immigration and Naturalization Services, was in the business of intruding in a lot of faith community spaces to make immigration arrests. And the most salient target of all were a group that called themselves the sanctuary churches. These were groups mostly operating in the American Southwest who were committed to the ministry of locating people from El Salvador, Guatemala, Honduras, Nicaragua, and others displaced by the Reagan administration's foreign policy decisions, and ferrying them to Mexico, then through the southern border of the United States, and from church basement to church basement in a way that was explicitly modeled after the work of the Underground Railway during the days of slavery. These churches would provide immigrants and asylum seekers with shelter, food, jobs without work papers, all in a way that drew the ire of the Reagan administration. And INS was in the practice, among other things, of conducting sting operations in these churches. So ICE agents, effectively, would infiltrate these churches, pretending to be members and volunteers at their migrant ministries, going from sometimes across borders to be able to accompany these people, as well as to keep a live wiretap on the sort of conversations they were having in a way that evidenced the way in which these churches were participating in the smuggling or the harboring of immigrants across national borders. After years of worshiping, praying, and serving with these migrant ministries, the INS agents eventually turned over the information to the FBI and then the DOJ for criminal prosecution. And they made a federal court case out of it. One of my law school professors, Paul Hoffman, represented many of these churches in criminal litigation and tried to suppress the evidence that was being brought in by these undercover INS agents pretending to be church members. The faith leaders, despite their dire straits, were galvanized by what they felt was a really strong argument that what they were doing, the ministry that they were engaged in, was a core part of their religious liberty and exercise as faith communities, that rendering aid to these immigrants, and especially asylum seekers who had been displaced by the Reagan administration's foreign policy decisions, was an integral part of how they understood the gospel or their practice of Christianity to look like. For various reasons, this was a losing legal argument, though a compelling moral one. The federal courts around this time were consolidating around the legal doctrine that would crystallize in a case called Employment Division v. Smith, which held in the context of peyotes and faith communities that sanctified it, that an otherwise neutral public safety regulation, like a ban on peyotes, was not going to violate the First Amendment, no matter how great the incidental burden such restriction placed on religious liberty, like, for instance, communities for whom using peyote was an integral part of their religious practice. And so using this reasoning, the courts were very clearly going to not entertain a religious liberty claim in the context of churches that were in express civil disobedience to laws that prohibited the harboring, concealment, or the transportation of undocumented immigrants. But the faith leaders felt strong, despite Paul's dissuasions, that this argument needed to be made in public in a court of law, to underscore to the American public the idea that the aid that they were rendering to these immigrants was in fact an integral part of their faith. Paul took some convincing, but eventually he did decide to write a portion of the brief dedicated to the religious liberty argument. Like a lot of ACLU lawyers, he was someone whose deep erudition and learning did not quite reach theology and religion. And so Paul had to learn about the Christian New Testament for the first time in his life. He sat down with these ministers for hours, for weeks at end, to eventually craft a portion of the brief that explained in detail why the gospel called to love all people regardless of their nationality, tribe, or social or legal status, compel these churches in particular to be good Samaritans and to be able to render particular and preferential aid to the most vulnerable immigrants then in the United States. The portion of the brief memorably ended with the line that the First and Fourth Amendments to the United States Constitution, taken together, must guarantee to the believer to gather together in their houses of worship in service to God and neighbor without the fear that one of their brethren will turn them over to Caesar's men for 30 pieces of silver. This is a compelling argument, rhetorically speaking, but as I mentioned to Paul, I wasn't sure if the theology was quite up to snuff, because as far as I understood the lessons of the Gospels vis-a-vis Judas Iscariot and the rest of Jesus' disciples, the lesson or the call so much isn't that we have a right not to be betrayed by our compatriots, but that we have a responsibility to share tables with one another, to break bread with one another, to love one another, despite the fact that others might sometimes betray us. The legal argument, as Paul told the faith leaders, didn't work. The federal courts did not entertain them. But it's important to note that the criminal prosecutions ended up being a bit of a political disaster for the Reagan administration. It was considered highly intrusive and unpopular for ICE agents to be going about in churches pretending to be members and turning over their clergy for criminal prosecution. And eventually the policy was reversed, first under the HW administration, and then under Clinton, there were the beginnings of what eventually blossomed into the Sensitive Places or Protected Areas memo, which was strengthened not only under Clinton, but later again under Bush, Obama, and the Biden administrations, which eventually came to be a federal policy that discouraged ICE raids and other civil immigration enforcement actions, not only around or at faith communities, but around shelters, food kitchens, hospitals, schools, and other social service delivery sites, which the administrations all deemed too important of a function to chill attendance through civil immigration enforcement. This policy was, of course, revoked by the Trump administration in its first day in office during its second term. And so part of the reason that we are gathered here today is to cover some of the legal landscape today on how to navigate the situation. I mention all of this partly to preemptively address what might be a rather conspicuous absence in today's presentation, which is that we are discussing today what it means to exercise our rights as faith communities seeking to be sanctuaries for undocumented people, asylum seekers, and other vulnerable immigrants, without much discussion of the free exercise clause of the First Amendment or of religious liberty more generally. Because of this case law, these precedents, the religious liberty arguments for rendering aid to immigrants tend to be quite weak. That being said, there are interesting cases and intervening changes around the passage of the Religious Freedom Restoration Act in 2005, as well as the current conservative majority of the Supreme Court being more amenable to religious liberty claims, at least those made by Christians, than previous courts have been, in a way that is interesting and important to lawyers like myself. But when we are engaging with faith communities, we don't want them to encourage them to rest on hypothetical rights that are still very much being tested in court. So we will have relatively limited discussions of religious liberties on that front. Second, and maybe on a more fundamental level, I bring this up as a reminder that we have been here before. Things may seem unnavigable and unprecedented today, given the vast and horrendous overreaches of our federal government in targeting and policing our neighbors, abducting them, sending them to prison or to other third countries, and harassing our communities. But in many other ways, we have been here before. We have faced rhetoric from our elected leaders, demonizing our neighbors, our friends, and our families, as well as legal policies that would target them, imprison them, deport them. And in that sense, we have been here before. And our faith communities have been here before, both in our role in being complicit in perpetration and injustice, and in our role in being a locus of resistance. We have been here before. And our traditions and our communities, both in the traumas that we carry and in the sources of wisdom and resilience that we offer, have been here before. And we're going to discuss today, as we already have done, some very heavy topics about what clergy can or should do when ICE carries off one of our members, or what kind of risks should we be prepared to undertake, even as we're exercising our fundamental constitutional rights. And these are moments in which require not only legal guidance, but also faith and courage, and for us as communities to stand together. And these are the moments in which I think it is the most important for us to remember that we have been here before. And so in this context, what does it mean for our communities to come together as sanctuaries? I think about it in three different terms. First, a sanctuary is a place of safety, and places that are committed to protecting our neighbors, our friends, our family members, ourselves safe from ICE raids, arrests, surveillance, and other immigration enforcement actions. Second, a sanctuary is a place of service that meets the needs of our immigrant communities and is able to accurately triage as well as to effectuate service programs in a way that minimizes risks, but also effectively improves the welfare of immigrant communities. And third, a sanctuary is a space for solidarity in which we learn to advocate for policies that protect our immigrant neighbors as well as advance their rights in meaningful ways. And we'll start with number one, what it means to be a safe space for immigrants. And we have to acknowledge first and foremost that this is not a safe time to be an immigrant in the United States. And it is no longer even a safe time to be a faith community that serves immigrants in the United States. As just mentioned, the Trump administration has rolled back the historical protections and the 30 years of administrative precedent, which once protected faith communities from civil immigration enforcement. And the administration has made a big rhetorical campaign, as was a part of Project 2025, that criminals will no longer be able to hide in America's schools and churches to avoid arrest. In practice, actual arrests have been alarming, real, and scattered, fortunately. There have been, I believe, around 5 or 6 documented instances of arrests in or around church property specifically, all of them typically in public spaces or outdoor spaces adjoining churches serving primarily Hispanic communities. Food ministries like pantries, kitchens, and meal events have been particularly vulnerable, often because they take place in public areas adjoining communities like parking lots or streets, which often create large enforcement bottlenecks, often of visibly non-white or non-English speaking communities that the administration is going to target under its racially discriminatory practices. And given the revocation of the historic privileges and the rights or policies that specifically used to protect faith communities and other social service delivery sites, communities now need to return to the exercise of their fundamental constitutional rights that all persons and all organizations and communities enjoy. And namely, those are the Fourth Amendment right to refuse entry of law enforcement into private property unless accompanied by a warrant, and the Fifth Amendment right to remain silent before law enforcement and to refuse further engagement. What should we do if ICE is at our door? And the answer as a faith community is actually quite similar to the answers that private property owners or immigrants who are facing ICE in their homes or in their businesses have been practicing for a very long time. And it is, again, to exercise these Fourth and Fifth Amendment rights to refuse entry and to be able to remain silent. So if ICE is at the door of a church ministry or a faith community entrance, the first and foremost, most important thing is to state unambiguously that you do not consent to entry into the property. And because faith communities are typically located in buildings that are private property, they have as much of a right as anyone to refuse this kind of law enforcement entry unless there is a warrant. Then they might ask a lot of questions or seek to engage with you or to cooperation with investigation, at which point you can always remain silent and exercise that constitutional right. when ICE visits, say that you don't consent to entry and then remain silent. Second, if and only if they state that they have a warrant, you can ask, is this in fact a judicial warrant signed by a judge, or is this an ICE administrative warrant, which might authorize arrest, but not entry into private property without a warrant? And if and only if they say that the warrant is a judicial warrant that has been signed by a judge, you can ask to see the warrant, ideally in a way that minimizes contact or exposure to the agent, for instance, by sliding under the door or through a mail slot, and along with the ID and the badge of the officer seeking entry. And if they do present what looks like a judge-signed warrant, even then, my advice generally would be to tell them, could you stay outside while we consult with an attorney or call a lawyer? Because it could be very confusing to know what's an ICE administrative warrant or what is a judicial warrant. Center of the screen, you can see like a little bit of a poster that shows the difference between an ICE administrative warrant and a judicially signed court warrant. And one way to do this is to be able to essentially post these kinds of distinctions on the inside of the outward-facing doors to your communities, so that whoever is in a position to open doors can distinguish between an ICE warrant and a judge-signed warrant when they are presented with one. The big problem with all of these Fourth and Fifth Amendment rights in terms of actual practice, especially for faith communities, is that law enforcement may enter spaces that are otherwise open to the public at large. And this is the reason that you can see NYPD officers, for instance, hanging out at local department stores or going into a bodega or a cafe. Because opening your doors to the public at large, or welcoming all people, is construed as what's called an implied license for anyone, including law enforcement, to enter into that space. And the easiest way that faith communities can essentially protect themselves against these kinds of unwanted intrusions is signage. The easiest way to do that, in fact, is to simply designate the entire building as private, and you've surely seen these signs all throughout the city and other places, or no trespassing, or other kinds of outward-facing communications that makes clear that non-members do not have the owner's permission to enter. Of course, with faith communities that are aspiring to welcome members of the public into their spaces, this needs to be balanced with safety. And what these communities might want to do when they wish to keep the entire building open to the public, or the building at large open to the public, for instance, their sanctuary, would be to designate specific areas within their communities as private, or I prefer generally the formulation members only, or staff and invited guests only. And service recipients and community members can sort of have a standing invitation to be able to enter, or an assurance that they are in fact welcomed in this space. But it's worth considering, even if you are hoping to be a very open community, a very welcoming community, to designate at least some high security or high sensitivity areas within the faith community building. Let's say rooms with shelter beds, rooms with English classes, or food pantries, or any spaces in which you are regularly gathering a large number of immigrants to be private or members only, so that law enforcement, even if they do enter a building without a warrant because it's open to the public at large, they can't enter that private space without a warrant or specific consent to entry. And you can imagine sort of walking into a restaurant that might otherwise be open to the public, but encountering a private room at the back of the restaurant that says like employees only, or no entry, or private. And those are ways in which the property owner clearly communicates to public at large who are otherwise entering the building freely that certain spaces are closed off. And this general communication applies equally to law enforcement, to a point that they would require a warrant or express consent to enter into those designated private spaces. And because this is all kind of difficult and legally indiscernible in some ways, signage is many faith communities' best friends in being able to actually keep their communities safe and to communicate these things clearly to law enforcement or to other members of the public. I would recommend that you all, if possible, are able to print out signage, depending on, again, how you're balancing your commitment to be a welcoming space to all persons, or your need to keep certain spaces strictly off limits to ICE CBP or other immigration law enforcement to post appropriate signage. And again, it could be as clear-cut or as radical or as safety-centered as simply designating the whole building private or for members only. Or it could be only to post signage on select locations, again, like rooms of shelter beds, designating them to be private. These are some other signage that could be a middle ground option. I don't know if you can read it here, but the top one says we provide sanctuary for all. And it states that this community or this space is one reserved for prayer, meditation, service, and love. And to this end, we do not consent to any immigration enforcement activities within our property. The legal effectiveness of this kind of signage, I think, is ultimately untested, even though it's certainly better than nothing. Again, because the way in which law enforcement has access to otherwise public spaces is ultimately the legal assumption or the legal fiction that they have implied consent from the owner to enter otherwise public spaces. At least theoretically or jurisprudentially, it makes sense that the property owner could withdraw the license or the implied consent to engage in specific behavior, much as a restaurant could, kick out or withdraw the implied consent for rowdy people who are harassing other customers or bringing drug detection dogs into the restaurant or something of that nature. Of course, having an outward-facing sign like this that says no ICE could draw unwanted attention to the community itself. And so I think communities also need to balance how much they want to signal their solidarity with immigrant communities. And I think in some ways, signs that directly say no ICE are best for communities that aren't actually serving a lot of undocumented people behind their doors, but are still hoping to show their solidarity as well as to be able to support their immigrant neighbors with a sense of safety. This is sort of another sign that we've come up with. And rather than trying to specifically exclude ICE, this one says no firearms permitted in property, including active duty law enforcement and military. And obviously a lot of faith communities, in fact, want to have this policy and would say, to the extent that you're carrying a firearm or another dangerous weapon which have been used to harm our communities, you do not have our consent as the private owner of this property to enter, even if you are law enforcement or ICE or the military. And this is a way to think about excluding law enforcement warrantless entry into your property without specifically targeting ICE, even though obviously, again, communities need to balance to what extent they might, for instance, have regular correspondence or a cooperative relationship with NYPD to interdict hate crimes or harassment directed against their communities, rather than being able to specifically exclude. Other posters, like this one that we've developed to the left of the screen for the Episcopal Diocese here, gives a nifty flowchart for what to do when an ICE agent attempts to enter. And it goes over the same information that we've already gone through, like this protocol for what to do when they try to enter, refusing entry and remaining silent, and what to do and what only to do if they claim that they have a warrant. A lot of this returns us to the discussion we were having earlier about the Reagan administration's criminal prosecution against faith communities that are striving to be sanctuaries for undocumented people and asylum seekers. So there is federal statutory prohibition on the harboring of undocumented immigrants, as well as for the obstruction of immigration enforcement and the facilitation of unauthorized immigration. And those were the laws under which the sanctuary communities of the 1980s were prosecuted. And while federal charges have not been brought against faith communities since the days of the Reagan administration, Texas Attorney General Ken Paxton has brought a harboring charge against a Catholic ministry house that provided shelter to immigrants crossing over the southern border. And so this is something for all of us to be aware of. But the important distinction here is that these are statutory prohibitions, whereas the Fourth Amendment right to decline entry unless accompanied by a warrant and the Fifth Amendment right to remain silent are higher laws than these constitutional prohibitions. And so to the extent that you're exercising your constitutional rights, it's not a statutory violation, nor can the fact that you exercise these constitutional rights be used as evidence against you in a court for prosecuting any of these prohibitions. So in a very practical sense, let's say you have someone whom you know or suspect to be an undocumented immigrant behind your door of your community. And maybe you're offering shelter beds, or maybe you implemented a shelter-in-place routine after ICE was spotted in your neighborhood. And you've closed the door, and there's a private sign in front of the door, and you're refusing entry. And if the ICE agent comes and says, like, we're seeking entry, where is this person that so-and-so run into this building? To the extent what you're doing is you can't come in here without a warrant, you don't have our consent, and not answering any questions about what the law enforcement is trying to solicit from you, including is such and such undocumented person behind your door right now, that's all protected constitutional exercise. And it is not a violation of the harboring or facilitation prohibition. It's a different story, though, if you try to lie and misdirect law enforcement, or if in a space that they've already entered, because it was, again, otherwise open to the public, you try to physically obstruct them, because those are not constitutionally protected rights, but are covered most likely by these statutory prohibitions on harboring and facilitation, or prohibition on concealing someone from immigration enforcement detection. Those would give rise to potential federal criminal liability. Or imagine that you are leading a faith demonstration or a protest in the streets against ICE. And maybe it's in response to the kind of ICE operations that often takes place in Canal Street. And you are protesting the enforcement action. Maybe you're blowing whistles. Maybe you're filming. Those are all things that are likely protected by the First Amendment to the United States Constitution as an exercise of free speech, expression, and press rights. But to the extent that you have specific signals that aren't merely drawing attention to ICE activity, trying to hold them accountable, but communications directly with people that the enforcement action is targeting. Let's say you've had a conversation of, run away that way to avoid drawing ICE attention. Those are all things that could potentially be liable as a matter of harboring or obstruction or facilitation charges to the extent they're not specifically covered by the First Amendment. And of course, every community needs to make its own determinations about how much risk they're willing to undertake. But it is important, even and maybe especially for communities that are engaged in express civil disobedience, to know what the contours of constitutional exercise of rights and a potential violation of law is, as they're taking efforts within and without the bounds of the law to be able to keep their neighbors safe. Moving on to the second topic for today's presentation, which is sanctuary as a space for service, and what kind of concrete steps can faith communities do to meet the needs of their immigrant communities. There are some very easy things that I think faith communities, especially as often spaces with physical spaces in their neighborhoods, can do to serve their immigrant neighbors. And I would say, before getting into any of the particular examples, I would encourage all faith leaders to be able to make connections with neighboring faith leaders who might be serving a lot of immigrants. And we see this a lot in interfaith spaces, where a lot of the groups that show up are members of liberal Protestant or Jewish denominations, where members are very committed as a matter of faith or a doctrine or as philosophy to serve immigrant neighbors and advocate for their rights, but often are serving very few immigrant members, whether in their religious or in their social services. And so it's really helpful for the priest or the pastor or the rabbi of those denominations to make connections with the local imam or priest of a Haitian Catholic church, and to be able to triage what kind of needs could be directed towards those communities and what the kind of services that the neighborhood actually needs are. And I want to highlight some particularly high-impact opportunities, including running a mailroom or a mailbox for local immigrant communities, especially after the Adams administration's decision in New York City to be able to evict immigrants out of the New York City shelter system, depending on their time of arrival in the United States after a certain period of stay. Address instability has become a huge problem for members of immigrant communities trying to keep up with their immigration court deadlines and hearings. because you often get what's called a notice to appear before an immigration judge or for an ICE check-in. But if your last registered address is not up to date with ICE or with the immigration court system, you might get what's called an in absentia order of removal from an immigration judge for failure to attend your hearing, or ICE might try to declare you a fugitive because you have failed to show up in your check-in. So having a stable mailing address, place-based mailing address, can be a really helpful thing for immigrant communities. I'd also really recommend gigs and contract boards. The legal landscape around the hiring of immigrants is a frankly bizarre and Byzantine one. It's not actually illegal for immigrants to work jobs in the United States. It's illegal for employers to offer regular employment repeatedly and knowing that the people to whom that they're offering employment is illegal. And there are some regulatory implementations of this policy, like requiring an I-9 or the use of E-Verify. But these things are only required insofar as what you're offering is, in fact, employment, as in hiring them as an employee. Immigrants are within their rights, and for the most part, individuals and organizations are within their right to be able to offer gigs or contracts or like short-term services. And it's really helpful for communities to be able to have these jobs boards, gig boards, or newsletters in which the kind of hiring positions that immigrants or even those without work authorization would be eligible for, like domestic or social services, language tutoring gigs, interior design, construction work, short-term stuff, can be given to people who need those kinds of gigs the most. A little note on sort of the basics of humanitarian immigration law for clergy specifically. A lot of what I was actually doing when I first moved to New York was encountering a lot of removal defense cases and litigating cases where a lot of people had filed asylum applications at the direction of their clergy, often with the assistance of faith community leaders during the sanctuary movement of the first Trump administration. A lot of these faith leaders had really the best of intentions and were very committed to helping their congregants and community members and the folks that they were serving get status. And they had heard somewhere that one of the ways in which undocumented immigrants can get status in the United States is to apply for asylum. And this, in fact, is often the only viable way that a lot of undocumented people have to be able to gain status in the United States. What a lot of these faith leaders didn't know is that if you're not currently in removal proceedings and you submit what's called an affirmative application for asylum before USCIS, the agency that adjudicates these things for affirmative applicants, and your application is rejected, you get actually referred to immigration court for removal proceedings, and you are now at the risk of deportation. And I ended up picking up as clients a lot of people who were in this situation. And I think the mistake is, to us, a highly relatable one, right? Because I think there is such a dissonance between the moral language or the theological language of asylum and refugee status and the legal language of asylum and refugee status. That's to say, if a pastor has a congregant who suffered horrific gang or domestic violence in El Salvador or Honduras, it seems like only a natural thing that they should apply for asylum in the United States and to be able to get status that way. But the high technicalities of American immigration law and the various injustices baked into it, for instance, makes this country a highly unfavorable forum for people seeking asylum on the basis of gender and domestic violence, because American asylum law requires not only harm suffered by the victim, but a government nexus to the kind of persecution or torture that the applicant experienced, as well as a rather strange requirement that the persecution was animated by a protected status like politics, religion, race, nationality, or sexual orientation. And of course, this in some ways is all morally and theologically irrelevant, right? Like, if someone is fearing torture and persecution back in their home country, why does it even matter if the persecution was animated by politics or religion? And if they're going to be killed by a gang or by their abusive spouse, like, they're going to be killed. And trying to demonstrate all these government nexus and otherwise meet the rubric of American asylum law seems like a strange exercise, and it is in fact unjust. But it does lead a lot of clergy to make a mistake and say you should apply for asylum, even if the best step for the undocumented immigrant to take in that step might be to try to lay low and to avoid interfacing with the federal government as much as possible. Another tough situation that we have to deal with is what faith leaders and clergy can do when a congregant or a community member is detained by ICE. And in an ideal world, all of this is a minimal rule, right? You just connect them with legal services and representation, and you take a step back until the lawyer tells you to, do something particular. But of course, we live in a legal reality in which a vast majority of immigrants and those in removal proceedings are unrepresented, often because they are unable to afford legal representation. And a lot of most heavily affected communities are not going to be able to pull the resources together to hire the very expensive immigration lawyers that they ideally should have. So faith leaders are often thrust into the unfortunate position of, taking the first calls when someone is taken into ICE and trying to be able to fundraise or coordinate social services. Here's some steps that I would personally recommend. Again, to the extent that you can't immediately turn the case over to a lawyer, that clergy can take. First, they can try to locate the community member or the congregant using the ICE detainee locator website. And this is really important because ICE is in the habit of routinely moving people around the country from detention center to detention center. And especially for people who are detained in states like New York, which have relatively few immigration detention centers, fortunately. But unfortunately, that often results in the detainee being transferred in very quick order to Louisiana, Texas, or another more hostile jurisdiction with more immigration detention centers. Another huge part of the problem is that most immigration detention centers at this point are run by private prison companies like CoreCivic or Geo Group, which makes the system highly fragmented. So the kind of support or access to the specific center of the community member's detention is also highly fragmented. And what typically you should do when trying to render services or connections to a detained person is, after ascertaining the location of that community member, to go to the ICE detention center directory and look for the specific detention center. And typically they will have instructions on how to post bail for someone in that detention center, how to get legal or clergy access to that particular detention center, as well as to be able to deposit money into the commissary fund that the detained person can use to buy food, which is typically pretty deficient in ICE detention centers, and sometimes even to be able to make calls to the outside world. And ideally, again, you would help them secure legal representation, and I'd really recommend the directory in the Immigration Advocates Network, where you can actually filter by specific immigration detention centers and see which legal services organization are supporting detained members in that center. And I'd actually also really recommend, to the extent possible, contacting your elected representatives about a detained community member. A lot of elected offices, especially the well-funded federal ones, will have dedicated caseworkers who can triage different kinds of legal need, or at the very least help people make contact with sort of other sources of support. And here in New York, you can very easily go to mygovnyc.org, see who all of your elected representatives are, and try to reach out to them. Maybe with a message that says something like, hey, I am a faith leader in your district that serves, X hundred numbers of people, and one of our people was just taken in by ICE, and we would really like your support in securing their release. Faith leaders can, and I think should, to the extent, again, feasible and to the extent it's necessary, have a community fundraiser. And GoFundMe obviously has been very popular for people who have been taken in by ICE, but I also recommend both Give Butter and Chuffed, which are more specialized for nonprofit and advocacy needs, and often have better interfaces and lower fees for something like a bail fund for immigrants. And having extra funds, I think, is good even if you don't have immediate legal needs, because, again, immigration lawyers are expensive, but chances are they might have to post a large and prohibitively expensive bail, which is typically set at $1,500 to $20,000 for detained immigrants, as well as to be able to provide trauma-informed care and other kinds of social services, even if someone is released from detention. Seeking bail is a traditional remedy for immigration detention, which can be sought first before ICE and then before the immigration judge, who is adjudicating the case of the detained person. And so to the extent that you have phone access or visitation rights to the person who is detained, probably the easiest thing to do is just to tell them, ask for bail. and to be able to seek that kind of hearing. Humanitarian parole is also something that's available for some detained non-citizens who are undergoing, for instance, an acute medical emergency or have a young child who could not receive adequate support without the presence of the detained person. And faith leaders can actually play a really important role in securing release, both in the bail and the humanitarian parole context. For bail, for instance, the main determinations for when someone is eligible or not is whether or not the detained person, if released, would, one, present a flight risk, that they would simply run away from law enforcement or other conditions of supervised release, and two, whether or not they would pose a danger to public safety. And faith community leaders can obviously play a really important and morally authoritative role in writing and speaking and testifying to someone's connections to the community that would make them a low flight risk, as well as someone's excellent moral characters that would make their release not at all a threat to public safety. And similar kinds of testimonials are very helpful for humanitarian parole. The writ of habeas corpus is something that you might have been seeing on the news a lot, and it's a mouthful to say, and it's very complicated, and it is itself an injustice that it's become such a central strategic bulwark in the fight for basic immigrants' rights. But the writ refers to something that you can submit to a federal court to review the lawfulness or the legality of someone's continued detention by the government. One really concrete way in which this comes up a lot is the administration mid last year released a policy saying even if you have been in the United States for years, and even if you haven't committed or don't have a criminal record that would typically make you ineligible for release on bail, we're going to keep holding you on bail, or keep holding you without bail anyway, as long as you entered into the United States without a visa or a parole. So anyone who entered without inspection, which is, I think, around 60% of undocumented people in the United States, the rest tend to be visa overstays. But in the former category, people are being denied bail even though they have a statutory right to bail under this new and illegal policy. And because immigration courts and ICE are controlled by the administration, by the Department of Homeland Security and Department of Justice, even though this policy is pretty clearly illegal, the administration has been enforcing it anyway. And the only way to challenge that kind of illegal detention these days have been to file for a writ of habeas corpus before a federal district court. And a vast majority of federal courts, in fact, there have been thousands of these cases already, have held that continued detention under those circumstances is illegal and have either ordered the detainee to be released or to receive a bond hearing. Commissary funds, hopefully this won't be necessary if any of your community members are detained, but if they're in there for a long time, it's very difficult in immigration detention centers, especially the ones that are run by private prison companies that have an incentive to squeeze costs. And so food is generally very inadequate, as is the ability to make contact with the outside world by phone or telephonic communications. And so it's really important often to be able to deposit some money into people's commissary funds so that they can buy food and make calls. These are all things to do when someone, a community member, is detained by ICE, but it's also good to engage in preemptive planning to be able to get ready for the eventuality. And this is especially true if, for instance, someone that you're serving has an immigration court date at 26 Federal Plaza Immigration Court, where substantial plurality of the immigration arrests in New York City have been taking place. Or they have an ICE check-in, especially if they're called in after having some kind of run-in with law enforcement and under which they were fingerprinted. And these are all circumstances in which ICE arrests are not unlikely. And in those situations, I would recommend meeting with the community member before to engage in some kind of emergency and contingency planning. I'd really recommend Human Rights First's Ready Now app, which allows you to load up essentially your emergency contact, any legal service providers that you would want alerted, paperwork. And as soon as you're being taken in by ICE, if you press the button, it will send all the documents and it will send all of the information about your location and circumstance of arrest to the extent you've preloaded it to all those contacts that you've preloaded. To the extent that the community member or the congregant has young children, also worth working with them ahead of time to assign temporary guardians or power of attorney over, kids or other people who might need to take custody or otherwise like handle access to your physical property like the home. And so these are all ways in which clergy can play a really important role in accompanying people as they're making really difficult decisions that bear heavily on their own and their children's safety. Also worth considering that you should register as a minister or as a chaplain who is able to visit ICE detention centers. And it can be a really important ministry for people who otherwise go without a lot of access to human contact and comfort. Again, it is a problem that access rules are very fragmented. A lot of detention centers will just have the instruction on the center directory website to contact the chaplain. Otherwise, they will typically have either office hours or like visitation hours to which clergy are sent. But if you're serving a lot of affected community members, I would really recommend exploring those options to view the ways in which you can support community members while they're in detention. Another thing that I really wish clergy serving a lot of immigrants would know is the humanitarian pathways for survivors of domestic violence. And there are three big ones, even though there are some others. One is a U visa for victims of crime who cooperate with law enforcement investigation of a crime. And typically, the visa issuance arises out of domestic violence situations. NYPD and other law enforcement organizations will often have a protocol in which after you've reported, let's say, a domestic violence incident, they will actually have a U visa certification process where they will complete a form for you that will accompany your application to USCIS that you deserve status because you have cooperated with the investigation of a violent crime. The Violence Against Women Act creates both a visa status as well as opportunity for something called cancellation of removal if you're already under deportation proceedings for survivors of abuse by a US citizen or permanent resident spouse, parent, or an adult child. And the special immigrant juvenile status is available for non-citizens under the age of 21 who are neglected, abused, or abandoned by one or more of their parents and who can line up a guardian to be able to help them. And it's not uncommon for me as an attorney when I'm like walking someone through like a very complicated asylum application process, for instance, to like learn 8 months into the process that like someone has been the victim of a qualifying act of domestic violence, which in fact might have been much easier than applying for asylum. Because of course, like, being a lawyer and who's not necessarily able to spend as much personal time or building rapport with clients as I would like, people don't necessarily want to open up about their experience of being a survivor of domestic violence during your first or second meeting with a lawyer who's often very rudely interrupting you as you're trying to tell your story to, make sure that everything that you're saying is within the rubric and the elements of American asylum law. And clergy and other faith leaders and care workers are often the only people to whom a lot of survivors confide these stories, and so often are the only people with the opportunity to be able to make the adequate referrals or to disseminate the information. Hey, wait a minute, you might actually be eligible for humanitarian status because of what you have experienced. And so it's really important for faith leaders to be able to know this. And when you notice that an undocumented community member has experienced this kind of violence or this kind of crime that might make them eligible for status, to at least encourage them to look into securing a lawyer or being able to submit one of these forms. And unlike asylum applications, the rejection of one of these applications do not lead to automatic referral to ICE or to immigration removal proceedings. So exploring these options is almost always a good idea. And to the third and final point about sanctuary as a space for solidarity. And I want to highlight, especially because we are hosted by state senator's office, that there's so much of a difference to be made in city and state level advocacy. I think a lot of faith communities, a lot of individuals feel understandably quite hopeless and experience a lot of despair at the state of our federal policy and the very limited voice that we often have to be able to make a difference in it. But there's so much happening at the city and state level that often receive very little attention or press coverage or calls to action that can really materially improve and affect the conditions of immigrants' rights as well as the welfare of our neighbors. I discussed a little earlier the Adams administration policy that had previously authorized the eviction of undocumented immigrants who are recent arrivals from New York City shelters, depending on their time of arrival in the United States. Recent arrivals, even though they're not really so recent anymore, were being evicted out of New York City shelters after 30 to 60 days, depending on age and family status. And that was a sort of thing where it was kind of a unilateral decision by the mayor's office, as well as the custodians of the court case that was in charge of this previous New York State constitutional right to shelter. And there remains a piece of legislation before New York City Council that would, in fact, codify into law the principle that right to shelter in New York is and should be a human right rather than something that is conditioned on your time of arrival in the United States or in your immigration or nationality status. New York City, as you might know, has sanctuary laws that purportedly prohibits the use of civil service time, personnel, resources, or like data for civil immigration purposes. But that's obviously a broad and important principle in a way that like leaves a lot of questions around the edges. And the current mayor has ordered an audit of a lot of the current contracts under New York City government and corporate services. And one thing I'd want to highlight, for instance, is the role of Clearview AI, which is an AI-powered facial recognition data surveillance company located here in New York City, and which NYPD uses for its facial recognition and surveillance capacity, but which also recently scored a series of major contracts with ICE. So there is a question of whether or not an NYPD officer entering the data of a New Yorker into Clearview AI, in fact, would go into the big database under which Clearview AI is enabling federal surveillance. So these are some concrete areas in which I think we should be speaking to our city council members. Again, you can go to MyGov NYC and ask what you've been doing to protect the shelter rights of immigrants or to ensure that our data is not being used to fuel ICE enforcement actions. And New York State law, of the kind that Senator Gonzalez has been very much a really important champion, is also a really important frontier for all of this. New York for All Act would make not just New York City, but New York State a sanctuary jurisdiction, or whatever that might mean. That would prohibit the use of not just city, but state resources for civil immigration enforcement. And this would bring disproportionate benefits to our friends and neighbors upstate, who oftentimes have conservative sheriffs who are cooperating very actively with ICE. Dignity Not Detention Act would prohibit the use of New York City and state facilities for immigration detention purposes. You might be seeing a lot of news about ICE buying out and converting warehouses across the country for the use in immigration detention. And Dignity Not Detention Act would place severe limits on that kind of capacity in New York City and state. Coverage for All Act would extend New York State Medicaid access to undocumented people in a way that would be incredibly helpful. We do happen to be in a relatively rare moment under at least the Republican trifecta control of presidency, House, and the Senate, where typically improvements of federal law are pretty unlikely, where there is a series of debates about appropriations riders for the Department of Homeland Security. And, if you haven't done so already, I would definitely recommend you to call our senators to be able to articulate our belief that our budget should reflect our moral commitments as faith communities for protecting our immigrant neighbors. And I think this kind of hyper-local and neighborhood-based activity actually can be not just highly effective, but something for which faith communities have a unique and outsized role in contributing to. A lot of local and state elections are decided by margins of a few hundred or a few thousand primary or even main election votes in elections that have 5% voter turnout. And neighborhood-based communities that have grassroots support and relationships and connections really do have a lot of weight before our local elected officials. So if you are a faith leader, I'd really recommend writing or calling your local electeds and saying, hey, my name is so-and-so, I'm a clergy member who leads a congregation in your district of 200 people, and I want to know today about what you're doing to keep our immigrant neighbors safe. Why has the New York for All Act, which is in your codes committee, been stranded in that codes committee for 2 years? Why aren't you moving it up for debate? What about Dignity Not Detention Act? What about housing for immigrant New Yorkers? have these conversations, and I swear that your elected representatives will give you a meeting with their staff or maybe themselves, as well as really taking you seriously. Again, because their hold over their seats often are pretty tenuous and rely heavily on grassroots organizing and the support of neighborhood communities. And I think this kind of involvement can, again, not just be good policymaking or like pushing people towards the right direction, but something that can be a helpful pastoral response to the kind of despair and anxiety that a lot of people, including clergy and faith communities, feel about the state of our federal politics, and a reminder that we really can make a difference in our city and a state level. Something that I've been thinking a lot about these days on a more theological level is some of the most beautiful traditions, theologically, mythologically, scripturally, from all of our faith traditions are those that underscore that the divine is to be found in the form of the stranger, that we might reach the judgment day or the day of revelation of what truth and justice really is, and for us to really realize that we have seen God before in the form of the visitor, the stranger, the vulnerable, the poor, the imprisoned. And I think that's what's really animating our commitments as communities that want to be sanctuaries for all people, which is something that at least I think about in terms of a place that is made holy and set apart by its radical non-deference to human hierarchies of status and power, which purport to divide us. And under medieval common law, debtors and fugitives could seek sanctuary in churches and other holy places, before which all distinctions or stigma of legal status were thought to dissolve, as we all stood equal in our mortality and humanity before the eternal and the divine. And we, of course, live in an era in which our government is engaged in severe and pervasive discrimination on the basis of parentage and nationality between human beings. But that makes it all the more important for us to be sanctuaries in which we live our lives and deliver services, and to be able to support policies that reflect our faith in a higher reality in which all persons are worthy of right, dignity, care, and love on the basis of our personhood, and not of parentage or place of birth. These sanctuaries, I think, importantly, provide us not just as a space for organization or for administering services, but as a place of comfort and nourishment in the midst of a time that is so full of fear and anxiety. They serve us as homes and as spiritual reminders that we, in fact, are and should be welcomed in the spaces around us before our loved ones. And, I just gave a long presentation about the rights that congregations have, as well as the legal principles that they can rely on to deliver services. It's to be able to advocate and be sanctuaries for their immigrant neighbors and community members. But legal advice can only go so far in this era. Legal advice and guidance is ultimately a series of assessments or predictions about what rules will be upheld by courts of law and what rights will be vindicated if it goes to trial. But these things only mean so much in an era in which our government is engaged in the summary execution and extrajudicial killings of our own citizens on our streets for exercising their fundamental human rights. And those are the times in which it is the most important for us to remember that we have been here before in the kind of fights that we have fought, the kind of injustices that we have had to stare down. Because the moment calls not just for legal analysis about what our rights are, theoretically, or as would be vindicated in a court of law, but for us as faith communities, as individuals, and as human beings to engage in discernment, not just about when prudence is appropriate or what legal judgments should be made, but when courage is necessary, when faith is necessary for us to be able to stand up for their rights. And that's why, as we're hopefully going into the session of organizing and cooperating and loving and serving together, I want us all to remember that we have been here before. Thank you all.